All right, guys, moving on to key knowledge 8 of this final outcome in Unit 2. This one, employer expectations. So the snapshot from the study design, as you see there, employer expectations such as contracts of employment, business loyalty, and terms of notice. So you'll see there that there are 3 things mentioned in terms of what study design is saying could be included in employer expectations. There are actually a lot more than that. And there's not a predetermined list. You could kind of discuss, but we'll kind of briefly go into some more. But the focus really of this will touch on the business loyalty, touch on terms of notice at the end. But to be honest, the predominant focus of this video is going to be on this contracts of employment and kind of expanding on some stuff that we talked about in the Key Knowledge 7 video as well. So basically, what's this about? Look, employers have expectations of their employees in the same way that employees have expectations of their employer. So in this topic, we're talking about the first one of those expectations that employers will have of the employees. And then in the next key knowledge topic, we flip it around and we look at those expectations that employees might have of their employer. So hopefully you understand what I mean there. So look, basically, looking at a real snapshot, if we were just answering this or looking at this whole key knowledge dot point in one snapshot, think about this. If you were running a business, what would be your kind of minimum expectations of your employees, or what would you expect from your employees? That's really what we're saying here. So first one, and that first one there is actually one of the things identified in that key knowledge snapshot there. So this is actually said in the study design. You would expect, hopefully, that your employees demonstrate some kind of loyalty to your business. And that kind of makes some sense. So that's actually the first point within the study design dot point there already. I mean, that's fairly obvious. You would also presumably hope that your employees would have come to work with some kind of a positive attitude. You hope that they're going to be dependable, reliable, cooperative. You're going to hope that they'll be willing to learn new skills when you need them to. And I guess you'd hope that they're willing to receive feedback to help them improve in their jobs, because if they're improving in their job, the business overall improves. So look, there's a little list of stuff that you could use in terms of, what could some employer expectations be. That's not the only list. You could come up with more, but, just for openers, there's a bit of a list there. Now, this is so one of the parts within that study design said about contracts of employment. So this is, like I said, I'm going to kind of go into a little bit more detail here, not a ton, but just kind of talking about some contract stuff. And again, a bit like with the last video, if you have a job or if you might be getting a job, some of the stuff I'm going to talk about in here could be useful to know. And in particular, the timing is kind of ideal here because I'm recording this very early October, and about a week ago, even less than a week ago, a pretty significant change was made in the laws surrounding casuals, which I'll get onto. So this could be a particularly useful video for you. Now, employers will require employees to sign a contract of employment, and that sets out the terms and conditions of their employment. Now, as we said in the previous video, if you're a casual, there might not be any signing of contracts done. It's all kind of done word of mouth, kind of unofficially. As I said there, so the contracts can be written or oral. Casuals, it's very rare that a casual is going to sign any kind of a formal contract of employment. It's all kind of, just done unofficially, orally, which, like I said in the previous video, does not mean that doesn't necessarily stand up in court. If things went wrong, an oral contract can still be equally valid, just kind of harder to prove than if things are written down. But look, the key here is, right, the contract cannot provide for less than, and when I say the contract, I'm talking about if you're casual as well, Whatever's in place cannot provide for less than the legal minimum requirements as found in what we call the National Employment Standards, okay, the NES. Now, employment contracts are governed by a piece of Commonwealth or federal legislation, the Fair Work Act 2009, and then brackets Commonwealth. For those that do not do legal studies, if you see an act of legislation, piece of law which has in brackets Commonwealth at the back, that tells you it's a federal law. And if it has in the back Vic, that will tell you it's a Victorian law. In the same way that if it had New South, NSW, that would be a law that applies within the state of New South Wales. But this one is a federal law. Now, most Australians' pay and conditions are set out in either an award or an enterprise agreement. So I touched on that in the last video, but I said, well, look, we don't need to know too much about those. We'll go into those in Unit 3, if you do Year 12, in a little bit more detail. Yeah, either an award or an agreement. Now, for the kind of jobs that you guys probably have at this stage, you would definitely be on either one or the other. And I would hope that you would know which you're on, if you're being paid according to an award or if you're being paid according to an enterprise agreement. Now, what is an award? So again, I said this last time. An award basically, it sets the minimum standards for employment for all workers within a particular industry. Okay, so it sets out the minimum wages that can be paid, and that will apply to different age levels. It will explain how overtime needs to work. It will explain how penalty rates work, how leave works, any other special arrangements. Basically, everything to do with the kind of setup of the contract of employment will be kind of detailed and itemized within that award. Now, an enterprise agreement is basically the same thing, but rather than applying to a complete industry, it will apply to what they call a workplace or an enterprise, because they're often called enterprise agreements, or basically a business. So let me just kind of give you an example of this, right? McDonald's, throughout their history, if you worked for McDonald's, right from when they first started here in Australia, if you worked for McDonald's, you were paid according to an enterprise bargain agreement. So an agreement, which was set up actually it was agreed between the union that represents fast food workers and the senior management of McDonald's. So basically there was an agreement paid. So if you were working for McDonald's, you were paid according to the McDonald's agreement, which meant, if you were 16 years old, you were paid the same rate as everybody else who was 16 years old working within the McDonald's business, but not necessarily the same as people working in competing fast food businesses. So KFC, Hungry Jack's, so on and so forth. Okay, so they were originally paid according to the McDonald's agreement. Now, I think it's February 2020, that agreement kind of came to an end. There was some legal wranglings over how McDonald's were dealing with penalty rates. And basically what it meant was that as of February 2020, McDonald's employees flipped over to being paid by the fast food agreement. So a national agreement, an award, which all fast food workers in Australia, that would be dictating their paying conditions, unless the business they worked in had their own agreement. So basically, they came off, McDonald's workers came off an agreement for McDonald's and went on to the national award for fast food workers. It was kind of an unusual move. Normally it goes the other way. Like I say, it was to do with some legality around penalty rates. Now, these awards that I'm talking about, as of September, October 2021, there's 121 of these in Australia, okay, set out. Lots of different, so like I just mentioned, the fast food award, there'll be like a retail award. All different industries have awards set up specifically for them. Now, coming back to these national employment standards that I mentioned before, okay, so these are the standards that are set out in law. set out within that Fair Work Act 2009, which all employment contracts, whether it's an award or whether it's agreement or whether it's an individual contract, which is another kind, when you become more senior, more professional roles often have individual contracts rather than these awards or agreements. But basically any type of employment contract in Australia, at the very minimum, they must adhere to these national employment standards. Now, I guess what's interesting here is that you yourself said there was 11. Until a week ago, there were 10. Okay, so for years, been teaching this course, and it's always been the 10 NES standards. Okay, but as of 27th of September 2021, there are actually now 11 of them, and that's a particularly important one potentially for some of you people. So look, these are outlined on the next couple of screens. Now, note while they provide minimum standards, you'll see from the language that the reality is that they kind of allow for some flexibility as well. Okay, just the way that they're worded, although they're supposed to provide minimum standard, it does mean that there is some flexibility in kind of the way that businesses treat these things. So it's not quite as black and white as it kind of seems, or as it kind of should be, really. So let's just look through a few of these. So these are the first 5 of the NES, the National Employment Standards. So maximum weekly hours of work, okay? So in the NES, it says full-time employee, 38 hours, okay? So a full-time week should be 38 hours. So theoretically, if you're a full-time worker, you shouldn't be requested to work more than 38 hours. But notice, like I said before, the little caveat, the language, it says that may be only required to work a reasonable number of additional hours. Okay, so what does reasonable mean? You know, it kind of leaves that term kind of a bit open to interpretation, leaves it a bit vague. And that's kind of how a lot of these things work. Look at the next one, request for flexible working arrangements. So it's written into law that in the workplace, you have a legal right to request some kind of flexible working arrangements. For example, if you have childcare commitments that you need to meet, or other, family commitments around caring for, someone within your family, a sick parent, something like that. If your circumstances change, you need some flexibility. You actually have the legal right to request that flexibility provided by your employer. Now, if you look at the wording here, right to request flexible hours until children reach school age, with employers only able to refuse on reasonable business grounds. Again, like the first one, what's reasonable? Who says what reasonable is? Very, very vague. The reality is it means it almost kind of completely detracts from what that standard is trying to achieve. And then all the rest here. So parental leave and related entitlements, annual leave, personal carers leave. Now, look, you do not need to know off the top of your head all of these 11 standards. Certainly be aware of a few of them and be able to explain a few of them. But yeah, you don't need to know off the top of your head all of these. So continue on, community service leave, long service leave. We talked about long service leave in the last video, public holidays, so on and so forth. So that's the 10. So if you look at any textbook that talks about the NES, then you're only going to find the 10 standards. But as I just said before, I said there's 11 because there's this new one. So as of September 27th, 2021, there's now another one that's been added in. And that basically says that offers and requests to convert from casual to permanent employment. So this is potentially particularly key for some of you guys that have jobs. What it means is casual employees who have worked for their employer for 12 months or more. So if you've been in a position for a year or more, your employer needs to offer you the option to convert to full-time or part-time permanent employment. So think back to that last video. We looked at the difference between working as a permanent employee, whether that be full or part-time. In your case at the moment, it's going to be part-time versus working on a casual basis. And, and you guys that have jobs, you're going to be either a part-time permanent employee or you're going to be a casual employee. And like I said, from my experience over the years, probably weighted more in favor of the casual employees for high school students in jobs. But if you are a casual, remember there were some disadvantages to being a casual, that lack of stability, lack of security, albeit you should be getting the high pay rate. There's definitely some downsides to being a casual. And students have talked to me, about this over the years, the fact that, suddenly they stop getting shifts, for example, and they don't know why. Well, when you're a casual, that can happen. And, you have no legal right to demand shifts. You're a casual. Your business will call you when they need you. So it can kind of put you in a bit of a precarious position being a casual. And businesses have kind of been exploiting their casual labour now for a number of years. Basically, the law has recognised this, and that's the reason for this law to be introduced, is to provide some kind of legal protection and some security for those in casual employment, because there are millions of people across Australia in casual employment. And it's kind of hard for them sometimes to kind of get the rights and the things that they're sort of entitled to. So the idea of this law is to kind of put some legal protection around casual employees by, like I say, offering the option, if you've been in place for 12 months or more, to actually convert, if you want, to this kind of ongoing or permanent arrangement. So this might apply to some of you, if some of you have been in a job for a year and you're a casual and, it's an issue to you, you'd rather be a ongoing or permanent employee, albeit part-time, then you now have the right to request that of your employer. Having said that, there are certain eligibility requirements on the part of the business. The main one being this does not apply to small businesses, and they define small businesses as being those with fewer than 15 employees. So if you work for one of the big retailers, the big fast food companies, then this should apply to you. But if you work for like a one-off cafe or something, or one pizza shop locally, then this may not apply to you. Depends on the number of employees. But worth noting, this is a really, really important piece of legislation that has been introduced, like I said, literally 5-6 days ago from when I'm recording this video. Now, one final thing. When you decide to resign from a business, you need to give notice to the employer. Now, at the very beginning of this video, we looked at the snapshot of the study design. It talked about loyalty to the business, contract of employment, and this was the other one about giving notice, okay? So when you resign from a business, you need to give notice. Now, if you're a casual, effectively, you say, I'm not working for you anymore, done and dusted, okay? But if you are on a permanent basis, whether it's part-time or full-time, basically, the period of notice that you give essentially lasts from the time that you tell the employer of your intentions to resign until the last day of employment, okay? Now, it would be expected that you would work your notice, but during that period of notice, you can take any accrued leave, sick leave, annual leave, anything that's owing to you. If you're going to take sick leave, you might need to provide a certificate, but you can use up your leave entitlements if there's any owing to you during this period of notice. You may also be asked to go on what's called gardening leave, okay, which means you basically say, okay, you go to your boss and say, I'm resigning, I'm giving you notice. And in terms of notice period, in either direction, if you were going to be asked, if you were being made redundant or if you're resigning, notice period generally needs to be at least one pay period. So if you're paid weekly and you're resigning, you need to give 1 week's notice. If you are paid fortnightly, then you need to give 2 weeks notice, monthly, so on and so forth. So once you give your notice, sometimes, and this probably wouldn't apply to you necessarily, in the kind of jobs that you're doing now on a part-time basis, but it may be that you give your notice and, if you're, say, for example, you're paid monthly, because this has happened to me in the past with recruitment companies when I've resigned. Okay, I've gone to say I'm resigning, I'm giving you my 1 month's notice. They say, yep, that's great. Collect your stuff from your desk and leave the building. Now, they have to pay you your 1 month's notice, but they don't actually want you to work that 1 month's notice. So they're sending in what they call gardening leave. It's just a term that's kind of arisen around this type of leave. Why would a business do this? They're going to basically pay you, but you're not going to be doing the job. They want you out of the business. Certain types of business, you might have access to certain information that if you're leaving the business does not want you to have access to. So, for example, I said in recruitment, on the computer, I have access to client list, for example. Now, if you're going to a competitor, the last thing they want is you taking the client list with you. So you'll find law firms, accounting firms, a lot of professional type people, once they resign, they're sent on gardening leave because there's information that you have access to which they don't want you taking with you to your next employer. And part of that might also be to sign a non-disclosure agreement to protect the intellectual property of the business. So, for example, client lists belong to the business and not to you, even though you were dealing with the clients. Those clients actually belong to the business and not to you as a person. So hopefully you understand what I mean by this concept of gardening leave. It's pretty common in the professional world. Another reason that you might send someone on gardening leave is that, look, once someone's decided they're going to leave the business, they're not going to be perhaps particularly upbeat about coming to work. They know they've already kind of gone mentally, they've already checked out, and it could be a bit of you might be a bit of a downer on the rest of the team that you're working with, and the owners or the managers of the business don't want that. They don't want you kind of slagging everybody off or bagging out the business, or maybe the managers in that final the final week, 2 weeks, 4 weeks, whatever it is that you're working there. It might just be better, let's just cut ties. We know you're going, we'll pay you, and you're the notice that we need to pay you, but we'd rather you were not actually physically working with us. So there are a whole bunch of reasons this can occur. Anyway, that is it for employer arrangements. In the next video, like I say, we'll talk about employee arrangements. We kind of flip this thing around. I will see you in that video. Cheers for now.